got it. I got it.
Oh, did you?
I got it.
They went full-time.
Yeah,
She wishes she was here.
I will.
it makes you feel better. I'll probably about
There are, but they're the police and then mom and Jessica.
Okay. I would entertain a motion to return to executive session, no action taken. Motion second, roll call.
Mr. Longmaker. Mr. Lewis. Mr. Connors. Ms. Sabah. Motion is carried 4-0.
Okay. Item 15, petition for proposed ordinance to prohibit high-impact data centers in the city of Edgerton to permit industrial nuisances, protect the property of its residents, and preserve municipal resource capacity.
On July 15th, the city of Edgerton received a petition for proposed ordinance to prohibit high-impact data centers. Copy of that petition.
Speak up, please. I'm sorry, I can't hear you over here. Thank you.
On July 15th, the city of Edgerton received a petition for proposed ordinance to prohibit high-impact data centers. A copy of that petition is enclosed with this packet. The petition references Kansas statute 123013, the petition for proposed ordinance. Additionally, Kansas statute 253601 describes the procedure to determine the sufficiency of petitions. Copies of both the statutes are enclosed with the memo for reference. Signature verification by Johnson County Election Office. The city submitted the petition to the Johnson County Election Office on July 16th to verify signatures as described in the statute. On July 20th, the election office notified the city that the process was complete via the letter enclosed with this memo. In short, the petition included 208 signatures submitted. Kansas law required 73 signatures, and 75 were accepted by the election office, thus meeting the statutory required number of signatures. Form verification by Johnson County Attorney. The city contacted the Johnson County Attorney as described in the statute to receive the written advisory opinion as to the legality of the form of the question. The Johnson County Attorney's Office provided the city a copy of the letter originally provided to Carrie Schmidt on July 2nd that confirmed the legality of the form of the question. Next step, petitions are allowed under 123013. Petition signatures have been certified by the county, and the question form submitted was deemed valid by the county attorney. These are only approvals as to the general form of the petition. Under the law, the city council may either 1, approve the petition without alteration as an ordinance of the city within 20 days after attachment of the city clerk's or the clerk's certificate to the accompanying petition, giving it the effect of being an ordinance passed by the city, or 2, the council may present the petition without alteration for a vote at a special election unless a regular city election is within 90 days. Statute 123013 also states that the provision of this section shall not apply to 1, administrative ordinances, 2, ordinances relating to the public improvement to be paid wholly or in part by the levy of the special assessments, or 3, ordinances subject to referendum or election under another statute. Tonight at the council meeting, city attorney will review with city council the standards for the petition and discuss options for council consideration. Any ordinance proposed by a petition that is passed by the governing body or adopted by a vote of the electors shall not be repealed or amended except by a vote of the electors or by city governing body if the ordinance has been in effect for 10 years from the date of publication, if passed by the governing body, or from date of election if adopted by vote of the electors.
Council, Mr. Mayor, I reviewed the law regarding petition and the petition itself. First of all, a point of emphasis. The county attorney's review is only about the form of the petition. It is not about the legality of the proposed ordinance that is contained within the petition. And in this case, according to the standards and law, this petition is legally and factually deficient. It should not be passed by this body nor presented to the city voters. In fact, I'm going to recommend at the end of this that the council approve the filing of a declaratory judgment suit to determine the validity of the petition. If the court determines that it is valid, then this can be submitted at that time, either approval or to the electorate. If it's determined that it's invalid, then it will be for naught, and we can proceed with other avenues to address these issues. Now, the reasons that I am saying it's legally and factually deficient, in brief, are that the body of the ordinance states several things which are not factually correct. They talk about the city's power grid, which the city does not have a power grid. They talk about agreements that the city has that the city does not have. They talk about the ability to control utility power corridors, which again is not something the city has control of. That is controlled and allowed by state law by the power companies who are KCC regulated. They're not regulated by the city. And as you know, in the areas we're talking about for data centers in the LP district, the city does not serve water in those areas. That is Johnson 7th Street. So any claim in there regarding service for water or power that says that the city has control over is factually incorrect. The other thing is that several spaces, the ordinance says that the city council funds, or the city council determines, and then states certain facts. I cannot recommend approval because this body did not make those findings. That's just a fact. You cannot be forced to adopt findings that you did not actually determine yourselves. So those are two areas where it's deficient. The legal deficiency is the statute 12-3013E says that the ordinance cannot be administrative. In my opinion, after reviewing all the cases, this matter is administrative. It is attempting to control either through a nuisance procedure or a zoning procedure that which is administrative with the city and therefore could not be properly passed. Now, if you choose to authorize the suit, what we'll be doing is presenting these arguments to the court for a neutral determination of these issues. There won't be any summary disposition by myself or you guys or the planning commission or anybody else. It will go to a court. And the court will have hearings and it will review the law and review these facts. It'll make a determination. And at that time, whatever the determination is, we'll return with that and ask you to proceed accordingly. So did I get everything? Okay.
So Todd, what kind of time does it take for court? I mean, my experience with court has been pretty long.
There is no way to set a timeline on a court proceeding. However, it would be my position that this is best proceeded with a temporary injunction proceeding, meaning that you would have a pretty quick hearing to determine if there should be a freeze during the time that validity is decided. So that would be an initial stage where some of these things would be discussed with the court, and we could have a good feel for maybe the way the court would ultimately rule. That's not for sure, but at least it gives kind of a quick, within 30 to 60 days determination about where we're headed. And usually these are not detailed fact cases like you guys have had in the past where you've had to go through a lot of discussion about who said what when, paperwork and all that. These are mostly legal questions. So the judge doesn't have to have an extensive factual background to determine things. So we would hope to do it with all due dispatch. And historically, the Johnson County Court has done a good job of attending to these things in an appropriately speedy manner. So we will keep that in mind in this process and try to keep this moving forward in a manner that is fair, but also disposes of it without too much delay.
So, I mean, and then Todd, does anything prohibit us, the council, from, or the city really, not even just the council, because it take planning commission too, and proceeding with processes that would, take some of the concepts in this and potentially make them legal concepts that could be enforceable?
No, you're allowed to take anything from this that you wish, or add different terms and create your own, and present it, pass it, at any time.
Questions? Council?
Yeah, so in a judicial hearing, who would represent the city side?
I would.
And who would represent the citizen side?
Sorry?
Who would represent the citizens who filed the petition?
Well, that's a complicated question, because you can't actually force anybody in this instance to be a defendant. Technically, anybody who signed the petition could be a defendant. But my thought is that there shouldn't be a block to anybody who wants to be, if they signed it and they want to be in the defendant and be heard in this, that's up to the court. So, I mean, the defendants can be anyone.
Question? Good question.
And just as background, oftentimes in other cases, there's been corporate groups that have been created to advance these things, and they're usually the ones that are named. So if anybody wants to give me a corporate name, I'd be glad to take it up. But, I mean, at this point, I've got to go with what the law says, which is that the real parties in interest are the ones who signed the petition.
Other questions?
I'll make a motion that we pursue that option.
So I take that as a motion to pursue declaratory judgment suit and what was the other one?
Well, to authorize city attorney, city administrator, to file an action in Johnson County for declaratory judgment regarding the petition.
Does that sound correct?
And maintain.
And do you need the secondary piece for the timeline? The injunction or whatever the other one?
No, that's,
Okay.
I mean, that's,
Okay. Dusty, read that motion back, would you please?
Motion to authorize the city attorney and the city administrator to proceed with the declaratory.
Sorry, we can't hear you.
Can't hear you.
A motion to authorize the city attorney and city administrator for a declaratory judgment regarding the petition.
So that's a motion and a second from Deb.
Right, I have Mr. Longnecker and Deb.
Roll call.
Mr. Longnecker.
Aye.
Mr. Lewis.
Aye.
Mr. Connors.
Nay.
Ms. LaBakken.
Aye.
Motion is carried 3-1.
Okay, I'm gonna go back to what I was saying, that I actually think that we should start moving forward with the city process. That would actually be an enhanced process to, work towards, citizen participation or input into the process as best we can.
Can you speak up a little bit? It's hard to tell what you're saying.
So, what I'm saying is, I think we should still move forward with a city process that would include some of the items in the legal means, that would include, some type of mechanism for, citizen participation or input. And so my recommendation is that staff would, start to dig into that and then bring back a process for us, so that we can start moving forward.
So just to clarify, so we have our direction to go, you're talking about using the standard text amendment process to go through to add additional regulations or consider text amendments to the Unified Development Code. And so staff would bring forward a plan to the governing body to consider that action.
Yes. Is there any questions or comments on that? mean, obviously, we wanna take the legal path, and the legal path for us looks a little different than this ordinance.
Right, but it's, I mean,
so-
it's something to start with.
So, but yeah, well, and I think, like I said, I want additional input as well, and I think staff can work, or bring back.
Yeah, so we would put together a plan, like a scope of services that would help outline how to go through that process, what type of, I think it's worthy to consider third-party consultants that might help us through that process, especially if you all want to talk about citizen engagement or the code rewrite, all of those sorts of things. Again, bringing back a plan and a scope of services so that you can authorize those things going forward, because you're going to need a chunk of time to do that, and then how a plan or a method in order to do that.
I don't know about you guys, I'm a fan of the third party idea to be a neutral party to help us with this.
So it'd be I would expect it would be something similar to what we've been through, like with the comp plan, right? So you have a consultant that's coming in, putting together, helping us, like first we would put together a scope of services to present to the governing body, you would okay that, and then we would solicit those proposals from other outside firms. Again, trying to look for folks that specialize in public engagement, and then those that specialize in the detailed work of changing the Unified Development Code or text amendments. All of that feeding into the statutory process to actually change those rules and regulations.
Because it would have the plan commission process,
Correct.
your review of that ultimately.
And the regular process, which public hearings.
Public hearings,
All of it.
before the planning commission, before the city council, all of those sorts of things.
But ultimately, you choose a firm so that you can get them to voice
So,
our opinion.
this isn't really time for the
Yeah.
public, but you can most certainly call in and have that question. Okay, is there any other questions from council?
Yeah.
Okay, everybody comfortable with that direction for staff? Okay. Future meeting reminders, July 23rd, city council meeting, August 11th, planning commission, August 13th, city council meeting, August 27th, city council meeting, September 8th, planning commission, September 10th, city council meeting. There's a list of events down at the bottom of the page. No further business, I entertain a motion to adjourn. All in favor? Opposed? Motion carries.
She chooses someone. She chooses someone. Todd and Ben choose people to give us our notes.